Section 11. How liberty was restored. We have now shown how the government of England turned absolute. We shall next consider how liberty was restored, and what security the British have for the possession of it. The Act of Henry VII allowing the nobility to dispose of their estates had already placed them entirely on a level with the commons. Elizabeth, who always affected popularity, was continually unwilling to impose taxes on her subjects. In order to supply her exigencies she sold the royal demesnes, as she knew that none of her offspring was to succeed her. Her successors therefore, standing in need of frequent supplies, were obliged to make application to parliaments. The commons were now become very considerable, as they represented the whole body of the people, and as they knew the king could not want, they never granted him anything without in some degree infringing his privileges. At one time they obtained freedom of speech, at another they got it enacted that their concurrence should be necessary to every law. The king, on account of his urgent necessities, was forced to grant whatever they asked, and thus the authority of the Parliament established itself. A peculiar advantage which Britain enjoyed after the accession of James I was that as the dominions of Britain were every way bounded by the sea, there was no need for a standing army, and consequently the king had no power by which he could overawe either people or parliament. The £1,200,002 a year which was settled upon the king at that time might have secured his independency, had not the bad economy of Charles II rendered him as indigent as any of his predecessors. His successor was still more dependent, and was forced to quit the throne and the kingdom altogether. This brought in a new family, which, as the royal demesnes were entirely alienated, depended wholly upon taxes, and were obliged to court the people for them. Ever since, the king's revenue, though much greater than it was then, depends so much on the concurrence of the Parliament that it never can endanger the liberty of the nation. The revenues at present consist chiefly of three branches, to wit, first, the civil list, which is entirely consumed in the maintenance of the royal family, and can give the king no influence, nor hurt the liberty of the subject. Secondly, the annual land and malt taxes, which depend entirely on the Parliament. Thirdly, the funds mortgaged for paying off the public debts, such as the taxes on salt, beer, malt, and sea, levied by the officers of custom and excise. These the king can by no means touch. They are paid to the Court of Exchequer, which is generally managed by people of interest and integrity, who possess their offices for life and are quite independent of the king. Even they can pay nothing but to those appointed by Parliament, and must have the discharge of the public creditor. The surplus of the mortgages goes into what is called the sinking fund for paying the public debt, which secures the government in the present family, because if a revolution were to happen, the public creditors, who are men of interest, would lose both principal and interest. Thus the nation is quite secure in the management of the public revenue, and in this manner a rational system of liberty has been introduced into Britain. The Parliament consists of about 200 peers and 500 commoners. The Commons in a great measure manage all public affairs, as no money bill can take its rise except in that house. Here is a happy mixture of all the different forms of government properly restrained, and a perfect security to liberty and property. There are still some other securities to liberty. The judges appointed for the administration of justice are fixed for life, and quite independent of the king. Again, the king's ministers are liable to impeachment by the House of Commons for maladministration, and the king cannot pardon them. The Habeas Corpus Act, by which the arbitrary measures of the king to detain a person in prison as long as he pleased is restrained, and by which the judge who refuses to bring a prisoner to his trial if desired within 42 days is rendered incapable of any office, is another security to the liberty of the subject. The method of election, and placing the power of judging concerning all elections into the hands of the Commons, are also securities to liberty. All these established customs render it impossible for the king to attempt anything absolute. Besides all these, the establishment of the courts of justice is another security to liberty. We shall therefore consider the origin of these courts, the history of them, and their present state.